Good evening. I really want to thank Memorial2007 for organizing tonight's lecture. And I especially want to thank you. I've met you today. I understand what people radiate when they stand next to me. And also thank you very much, Professor Kingsley Abbott. But I especially welcome you, the guests who have come out tonight to hear this lecture. I hope that by the end that we can enter into conversation. This evening, I will speak about remembrance and how we remember, and mostly how we forget features of the slave trade. And we forget that to our peril and to that of the rest of the international community. Such forgetting or obliteration of the past denigrates our perceptions of the present. However, what is obliterated by memory never really disappears, just ask your psychologist. It submerges, then it resurfaces. It re-emerges, almost with a sturdy determination to carve and sculpt out your current existence. Hence, my remarks are entitled, The Reemergence of the Eternal Slave Trade. The remarks largely derive from my persistent delving into international criminal law as a practitioner, a scholar, as an eternal student, and as a descendant in honor and respect of my enslaved ancestors. So where do we start? It can be impossible sometimes to identify that precise historical moment when an epoch begins. Africa's population underwent the brunt of both the East African and the transatlantic slave trade and slavery. The Portuguese and the Spanish enslaved and slave traded in the Mediterranean first, in the 15th and the 16th century, both in Sicily, Palermo, before installing plantations in Sao Tome. And then when they understood that that plantation system would work, they erected a colonial structure in the Americas, a structure that became synonymous with enslavement. British settlers first enslaved or attempted to enslave indigenous persons in the Caribbean and in North America. But then they embarked upon erasing the indentured status of those Africans who were in those British colonies and who resided there as indentured servants. They erased that and transformed them into chattel, thus instituting hereditary slavery. The 17th, 18th, and 19th centuries of enslavement in the Americas and the Caribbean was a persistent manifestation. It was a complex, multi-generational institutionalization of inhumane indignity. We can see the different slave groups here in this slide. Enslavement often focused on images of plantation slavery, fields of cotton, cane sugar, rice, indigo, coffee, or tobacco. But gone are our recollections that the enslaved also toiled in the darkened underground mines in Brazil. And the majority of African slaves went to South America, to Brazil. And today there is a state fittingly called Minas Gerais, the general mine, that is remembered for its slave labor. The enslaved also labored in sweltering, wrought ironworks in Cuba, as well as being carpenters, building those fine plantation homes in Jamaica. In urban centers, in both colonial and post-colonial United States, the enslaved were assigned to service, whether it be in stores, schools, factories, churches, and yes, cathedrals. We need to remind ourselves and to reiterate to others that the enslaved were stevedores, they were longshoremen, They worked in the harbors of New York, Charleston, Rio de Janeiro, and Bahia, as well as in Kingston, Jamaica. We also need to grasp that some slaves did absolutely nothing except exist in a condition of subjugation and be paraded around to affirm the wealth and the status of their owners. Those enslaved persons were more like human pets. The enslaved were also sexually enslaved. Male slave owners raped, to terrorize, to punish, or just to exercise their power of ownership. As historian Peter Holchin recounted, masters, their teenage sons on larger holdings, their overseers took advantage of the enslaved to engage in a kind of casual, emotionless sex on demand that was unavailable from white women. In the post-colonial United States, the enslavement of so-called fancy girls existed. These were enslaved females of mixed race, often with European facial features. They were kept in brothels or private homes for the sexual pleasure of the enslavers or their gentlemen acquaintances. Certain enslaved girls were specifically raised, or should we use the proper terminology, groomed to become fancy girls. And I think you here in Britain that I've heard on the news recently this week, you know about grooming girls to be used sexually. Sexualized and reproductive violence against male slaves was an essential aspect of slavery. Enslaved men had no control over their semen. Enslaved males were referred to as bucks, while females were specifically called breeding wenches. The enslaved bred the newborn, who then were enslaved. Forced procreation of slaves became associated with animal husbandry in the United States. The institution of breeding slaves was merely a practice to increase the slave owners' wealth, their goods, their ability to put up collateral, and to claim equity. Forced procreation, without a doubt, increased the anguish of the enslaved. Just imagine the enslaved parent who dreaded the approaching puberty of their children. When menstruation begins, sexual violence increases. Lesser acknowledged, but common sexual and reproductive violence related to slavery practice was committed by upper-class white U.S. females who were slaveholders. These women of a certain economic and social standing within their communities loaned and exchanged enslaved females for their breast milk. The enslaved women were called wet nurses, and their breast milk was used to feed white infants. Profit was made from the commodification of the enslaved woman's breast. In Brazil, the same practice occurred. It was called mercenary nursing. After such horrific imagination of what was really everyday slavery that endured for hundreds of years, I would now like to present the legal definition, the black letter law definition of what is slavery. The 1926 Slavery Convention that was promulgated by the League of Nations and then reiterated 3 decades later in the United Nations 1956 Supplementary Slavery Convention outlawed all forms of slavery. The convention defines slavery as the status or condition of a person over whom any or all the powers attaching to the rights of ownership are exercised. Slavery in all of its forms means that slavery recognized under the law de jure slavery, where you could show a piece of paper that proved you had title without law. But in addition, the slavery conventions outlaw de facto slavery, slavery that's just really a social cusp or a practice. The convention outlaws de facto and de jure slavery. So the slavery convention drafters intended to prescribe urban slavery, plantation slavery, educational, religious, and scientific institutional slavery, the grooming of fancy girls, raping, castrating, breeding, or procreation of the enslaved, commodifying the enslaved's breast milk, any form that evidence an exercise of powers of ownership rights over a person that was slavery without, the entirety of enslavement without. Hence, what appears to some as a very broad, abstract definition, legal definition, is really adept and all-encompassing. It doesn't have to list all the different acts. It allows you to know that it takes in the entire swath of enslavement. Here, my main intent tonight is to discuss the slave trade, or slave trading. I emphasize slave trading as a verb. Images of the transatlantic slave are usually laid out in that prior slide that I showed you of the slave ship. Or we think about these scenarios of abduction and capture, or scenes of placement on auction blocks for sale to enslavers. In the Americas and the Caribbean, and in Brazil and Colombia and Venezuela, that has resonance. However, less completely imagined are the scenarios of the dynamic internal slave trade. And by the internal slave trade, I mean the domestic slave trade, after the trip across the ocean. In the United States, the internal or domestic slave trade occurred as a notorious commercial entity. Slave markets were located in places like New York City, New York, Montgomery, Alabama, Charleston, South Carolina, New Orleans, Louisiana. This is the map of the internal slave trading routes. No oceans are crossed. These are the descendants of the original African slaves. This is hereditary enslavement. Enslaved persons as human cargo traversed ports, harbors, warehouses, depots. And they were conveyed internally throughout different states to city dwellers, to other rural plantations, to university campuses. Yes, and again, to scientific institutions, and particularly medical institutions where time experiments were done upon them. And also to religious edifices. Oh, those cathedrals. Many social strata of post-colonial United States engaged in the domestic trade. That internal domestic trade could really be called a commerce, because it was concluded usually by contract. It was used to redeem debts. It was used as collateral for loans and to back mortgages. Insurance companies in the United States very much enjoyed the internal domestic slave trade. Less recognized in the internal slave trade is how common the practice was among family members. How? By inheritance. The internal slave trade occurred by negating your slaves to others. Slave trade occurred in the form of wedding presents, birthday presents, graduation gifts, or bequests and donations to organizations and institutions. Interestingly, white women in the United States were disenfranchised, and they were not allowed to own real estate. during the era of slavery. But they could have a property interest over the enslaved. For example, Martha Washington, whose second cousin, George Washington, was the first United States president. Martha brought as her dowry into the marriage 84 enslaved persons. Martha had a proprietary interest in those enslaved persons. That internal slave trade was so ubiquitous that it had niche markets. There existed the trade in enslaved children. Children, boys and girls, usually enslaved by the very act of their birth, were a known commodity. They worked in sugar distilleries. They were offered as gifts to the children of slave owners so that they would always have a playmate. We remember the book Uncle Tom's Cabin and Topsy. As I mentioned before, mixed-race girls were groomed as fancy girls, meaning that they would be future sexual concubines. I emphasize that they were girls. I was reminded when I was a prosecutor at the Yugoslav Tribunal, I went on an investigation mission to the United States to talk to some refugees from Yugoslavia. I was sent to Kentucky. In Kentucky, enslaved boys were once used as the original jockeys in the Kentucky Derby, in the steeplechase horse race. That is why some lawns in the United States, until today, have a little black jockey holding up a lantern. That's a reminder of the internal slave trade. It enslaved children, and it was not inconsequential. Beginning in 1807, as you know here in the UK, bilateral treaties between Britain and Atlantic Ocean and East African slaving nations were entered into to outlaw the international slave trade. And that slave trade was gradually abolished. By 1825, the community of enslaving states acknowledged and acted upon what was a type of emerging legal obligation to stop the international slave trade. These bilateral agreements are by their nature cross-border interstate accords, certainly. However, the UK's 19th century objective with these bilateral accords was the intent to disband the international slave trade. The accords affected trading vessels on the open ocean of North and South Atlantic, the North and South Atlantic. In essence, Britain and those engaging states were very comfortable with recognizing and accepting the conclusion of a slave trade as long as it was conducted on the high seas, because it found a legal precedent in going after piracy on the high seas. So the banning of the international slave trade was a type of extension of the regulation of maritime traffic and passageway. But literally, those bilateral accords did not touch land. Halting the international slave trade was not intended to impinge upon domestic institutions of slavery. Slavery in the sovereign realm remained legal because the state's treatment of its own citizens, and particularly the state's treatment of stateless people, disenfranchised people, enslaved people without citizenship rights, was not to be the concern of another state. So the domestic or internal slave trade was not governed by the international bilateral accords that Britain entered into. Ironically, the ending of the international slave trade actually entrenched the lucrative market of the internal domestic slave trade in the Americas and the Caribbean. Moreover, it increased the abusive sexualized practice of slave trade and enslavement. A contemporary to the bilateral accords noted that, look, slaves multiplied so fast in Virginia and Maryland that it's really cheaper to raise them than to import them. Therefore, places such as Bahia, Brazil, the southeastern coast of the United States, and plantations in the Caribbean invested in more breeding, procreation, and husbandry of the enslaved. The enslaved were now bred to be domestically traded. Perceptions of fecundity, virility, and their reproductive capacity became very integral to advertisements of domestic slave trade. Even as the gradual abolition of slavery occurred in certain northern and western states within the United States, there did surge another legally permissible form of internal slave trading in the free states. It was based upon a federal edict known as the Fugitive Slave Law of 1850. The formal title of this law was, and listen carefully, an act respecting fugitives from justice and persons escaping in the service of their master. The title is almost more relevant. I understood today from Professor Abbott that this building has no relevant connection also. The Fugitive Slave Law recognized the return of formerly enslaved persons who had fled to non-slave territories in the United States. As such, the Fugitive Slave Law legalized acts of internal slave trading. So slave traders who tracked, hunted, kidnapped, jailed, and facilitated re-enslavement received the protection of the law. The self-liberated, derogatorily called runaways, received no protection. In 1859, the Fugitive Slave Law of 1850 was challenged in the United States Supreme Court in the case of Abel versus Booth. The Supreme Court upheld the Fugitive Slave Law and recognized the rights of internal slave traders and enslavers who received their goods. It denied justice for the self-liberated. But actually, the very first United States federal law that outlaws internal slave trading was written in military law. It was a provision of the Labor Code. The Labor Code is a humanitarian law instrument. And among international lawyers, the Labor Code is put on a pedestal, but not for the reasons I'm about to tell. President Lincoln is the one who issued the Labor Code. It was called Order 100, and it would govern the conduct of United States troops. But in reality, it only governed the conduct of the troops of the North, because the Southern or Confederate troops were in rebellion and had seceded from the Union. But the Labor Code as military law, for me, contained this remarkable set of articles. It ordered troops not to enslave free persons, not to re-enslave the enslaved, and to free any enslaved person whom they captured or whom cities they occupied. To do otherwise would be considered a war crime. So the Legal Code can be said to have inserted in the law of armed conflict a form of abolition by outlawing enslaving and slave trading of occupied enslaved persons. The Legal Code was issued 3 weeks before President Lincoln pronounced the Emancipation Proclamation that unilaterally freed the slaves in Confederate states who were in rebellion against the U.S. government. Again, the Emancipation Proclamation must be understood as not giving freedom to enslaved persons in any northern state or southern state who was not in rebellion against the U.S. government. So therefore, the states of Delaware and Maryland that were not Confederate states, their enslaved persons were not freed by the Emancipation Proclamation. They would have to wait until 1865 with the passage of the 13th Amendment of the U.S. Constitution. But abolition of slavery and the internal and domestic slave trade did continue within the Americas and the Caribbean. Cuba was the last country in the Caribbean to outlaw slavery in 1883. Brazil held the dishonor of being the very last country in the Americas to outlaw slavery in 1888, almost 100 years after Haiti's self-liberation of both colonialism and enslavement in 1790. And Britain freed their enslaved colonial populations when? Yeah, 37, 38. Well, that's in the vitality. Okay, gotta learn our history, right? So it's imperative that we really reckon with slavery in the Caribbean and in the Americas. How that imperative is impossible. However, that imperative is impossible if the full content of the internal slave trade is minimized. The internal slave trade was as much an ingrained institution, inextricably intertwined with slavery, as the transatlantic slave trade. The breadth of the internal slave trade, to my mind, has not been thoroughly assessed by today's advocates, and therefore not properly memorialized when we think of the slave trade. To de-emphasize or fail to grasp not just the thousands of crossings of the West from Western Africa through and across the Atlantic, but also not to look at the millions of acts of internal slave trade, means that we have shunted something from our menu. So now I would like to talk about what legally is the slave trade. What is the prohibition of the slave trade today, whether international or internal? Well, basically, the slave trade is when you reduce a free person to a situation of slavery, or when you dispose of an enslaved person to another situation of enslavement. So let's examine that a bit closer. The 1926 Slavery Convention that I spoke about earlier defined slave trading and prohibited it also. The 1956 Supplementary Convention by the United Nations again reiterated the same definition of the slave trade and prohibited it. We have to understand how black this black letter law is. The definition of a slave trade has three categories or types of conduct. And let me briefly go over those with you. But I put them in separate slides because I want that to be seared into your mind. So the slave trade includes all acts involved in the capture, acquisition, or disposal of a person with the intent to reduce him, my place, her, him or her, or that person to slavery. Think about that. Any way that you become free, that you are free and you become enslaved, whatever that act was, is the slave trade. Disposal is a wonderful word for lawyers. It is so broad. The next part of the definition of the slave trade is that all acts involved in the acquisition of a slave with a view to selling or exchanging him or her. What this really means is that the enslaved can continue to be slave trade. It is not a one-time act. So anytime the enslaved are further acquired, sold, exchanged, they are slave trade. And then the third part of the definition of the slave trade are all acts of disposal by sale or exchange of a slave with a view to being sold or exchanged, and in general, every act of trade or transport. Now, this one sounds like a mouthful, but what it's basically saying is that when you have a series of slave trading before you get to the next situation of enslaved, each of those acts, each of those means is slave trade. And all forms of transport of the enslaved to different places were slave trade. The 1956 convention did add an additional form of transportation, and that was the airplane. Because I think between 1926 and 1950, airplanes became more common. So the transport of the enslaved on airplanes is slave trade. So the slave trade's legal prohibition is comprehensive, although I think it is understudied and not well known. But surely this definition, so broad, drew upon the historical enslavement and slave trading of Africans and their descendants in its criminalization. It picks up conveyance of any kind, bequeaths, lottery bets, rewards, inheritance. It picks up the wooden wagon that takes the enslaved to the next place. What must be understood by contemporary international lawyers, but more importantly by the international community, is the relevance of the definition of the slave trade. The other thing is that the slave trade is a precursor almost to every act of enslavement. The only time that I can think that someone has been enslaved and not first slave traded is probably at birth, the newborn enslaved infant. We have to understand there's a relationship. Slavery and the slave trade occur in tandem, yet each is an egregious international crime in its own way. So keep in your mind this slave trade and slavery framework. This is the legal framework. The slave trade is analogous to the transfer of illicit goods without having to own those goods. So we think of the captain of the ship who's transporting a cargo and doesn't own the cargo, but is responsible for the cargo to get it to another place. That person, when they're doing it with people who are free, about to be reduced to enslavement or enslaved people, is slave trading. The slave trader, unlike the enslaver, doesn't have to exercise powers of ownership over the cargo. And it's important to understand that slave trading is not a lesser included offense or a subset of slavery. It stands on its own as an international crime. Each of those crimes is distinct and really not overlapping, although the slave trader might be an enslaver and the enslaver might be a slave trader. The slave trader might intend and therefore act to reduce a person to enslavement, and then maybe learn that the potential buyer does not want to buy, does not want to enslave. Has an act of slave trade been taking place? Yes. The slave trader does not have to have a successful buyer. Thankfully, the person who was intended to be enslaved remains free, even though an act of slave trading has occurred. And there's one last legal point that I must underscore. Consent, the consent of the enslaved, is legally immaterial to slavery crime. It is not legally relevant whether a person says, I would want to be a slave, or I would like to be slave traded to this plantation so that I can see my daughter, or I would like for you to buy me so that another more evil enslaver doesn't buy me. All of those forms of consent of the enslaved are legally immaterial to prove that slavery and slave trading occur. Slavery and the slave trade, international and internal, are the legal legacy of our ancestors. I would like them to be respected. However, a peculiar phenomenon, a peculiar legal phenomenon, has happened with international law application of these international crimes of slavery, but in particular of the slave trade. Granted, the 1926 and 1956 slavery conventions are cornerstones of international law. Granted, the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights recognize slavery and the slave trade as non-derogable, meaning no exception given, human rights violations. As human rights violations, they have the highest value. Whether in peacetime, whether during times of war, or during political emergency, you have the human right not to be enslaved or to be slaves. And granted that additional Protocol 2 to the Geneva Convention and Rule 94 of the International Committee of the Red Cross prohibit both slavery and the slave trade as war crimes, whether it be international armed conflict or in civil war. That's a bit of a legacy of the legal code. But the Rome Statute, the constitutive instrument of the International Criminal Court, that is thought to be as authoritative, listing most of the most serious international crimes, contains no provision and therefore no redress for the slave trade as a crime against humanity, or slavery and the slave trade as war crimes. Why is that curious? It's curious because there are a lot of cases that come before the International Criminal Court, such as in Uganda and Rome, that hear evidence of armed conflict-related capture, abduction, conscription, and enlistment of child soldiers. Where you might say, Patricia, what's the relevance? Well, to accurately describe and to offer a full legal characterization of those facts, judges have begun, since the Special Court for Sierra Leone, to recognize something that's quite evident. Child soldiers are enslaved children. Kidnapping, abduction, recruitment, or conscription, and then their reassignment to different military units are euphemisms. They're synonymous with slave trade. Child soldiers are enslaved children who are repeatedly slave traded. There are other facts and relevant evidence that is coming from the International Criminal Court that concern the abduction of women and girls, who then become these forced conjugal partners who enter into forced marriages with militia fighters. The women and girls are redistributed to successive militia fighters. Upon the death of one fighter, they're then given to another so-called husband. The abduction of these women and girls and their distribution and redistribution is really slavery, sexual slavery, and slave trading. So what is happening in international law, in our everyday psyche, that we hesitantly recognize and understand slavery crimes, and that we are those to recognize and redress slave trade? Moreover, national codes, I would say, have the same psychic quandary. National criminal codes rarely contain provisions for the slave trade. The Netherlands and Liechtenstein are among the few European exceptions. The United Kingdom does not contain provision that criminalizes the slave trade on its own. What has caused this erasure? One word: trafficking. We hear a lot about trafficking. As a matter of fact, trafficking substitutes for what we should be saying slave trade. Trafficking is a transnational crime that sometimes crosses borders, but can occur within a state. It has diverted some of our legal attention from the Redress of the Contemporary Commission of the International Crimes of Slavery and the Slave Trade. Trafficking as a transnational crime is found in many penal codes, but most of us do not really understand what is the origin of trafficking. trafficking convention started, as you can see, in the beginning of the 1900s. They were drafted in 1904, 1910, 1920, and they were originally called, and I couldn't make this up, the White Slavery Convention. And they were called the White Slavery Convention because they applied to white girls and women who were taken across borders for illicit purposes. Their conventions about morals. Their protection was later expanded to all women and children. And today, trafficking is found in the Rome Protocol of the United Nations Convention on Organized Crime. Now, trafficking might factually resemble the slave trade or enslavement, but it's not the same, and they have been terribly conflated. But you can understand that you have a 1926 slavery convention on one group and a whole other group of trafficking conventions for white slavery. Their origins, their subject matter, what they are to prohibit, were completely separate. And that emphasis now on trafficking has led to the erasure of the slave trade, both under international law and under domestic penal codes. The slave trade is an international crime. And unlike trafficking, it does not require proof of the use of force or coercive circumstance. And if there is force and coercive circumstances with slavery or slave trading, it's legally irrelevant. What we're looking at is the intent of the slave trader or the enslaver. To establish the slave trade, there is no requirement that you have to prove exploitation. To establish slavery, you do not have to prove exploitation, although, yes, most slaves were exploited. Remember what I said before. The enslaved do not have to do anything. It is a status or position that is per se undignified. So today's legal language often prioritizes what I call a false legal hierarchy, trafficking over slavery, and in particular trafficking over the slave trade. And I would not hesitate to suggest that the slave trade is a difficult word to pronounce. It's weighted. Yes, it brings history. And yes, it might cause uncomfortable or even guilt. Trafficking removes the guilt, removes it from the state to the individual, removes it from the weightiness that those institutions develop. And it only points a finger where? To organized crime, not to international lawful acts. Trafficking does reach horrendous comment. I am not saying that it doesn't, as you did see this week in Britain. But it doesn't substitute for the prohibition of the international crime of slavery and slave trade. But our uninformed psyche that is trying to repress things that make us uncomfortable have led to misguided legal codes and statutes and erroneous conflation. However, there is a re-emergence of the international crime of the slave trade. It is underway. Sierra Leone, who is vice president of the International Criminal Court, and of course an Assembly State Parties member, has proposed and has been supported by many countries in Latin America, Africa, and the Caribbean, has proposed to amend the Rome Statute. The proposed amendment would enumerate provisions for the slave trade as a crime against humanity under Article 7, and it would amend into Article 8 that covers war crimes, both slavery and the slave trade. So in December of this year, the Assembly of State Parties will vote upon what is now seen as almost a non-contentious amendment to add the slave trade as part of crimes against humanity, to make the yellow donut hole, and to add both slavery and the slave trade as war crimes, to make the brown donut hole. Until today, the UK has not signaled support of this amendment. So there is advocacy to be done. Another part of the reemergence of slavery crimes is that last year, in December, as Special Advisor for Slavery Crimes, I had the honor to develop the slavery crimes policy of the Office of the Prosecutor of the International Criminal Court. It was the first time that an international judicial body examined its current strengths and weaknesses in relationship to the adjudication of slavery crimes. The policy speaks to investigators and to lawyers and to Assembly State Party members with their complementarity of jurisdiction, but it also speaks to you, the public, because it begins with the historical acknowledgement of the institutions of enslavement and the slave trade. And it encourages, it tells investigators and lawyers to be aware of the history as you are investigating today. Because by not knowing the history of enslavement throughout many parts of the world, but in particular the transatlantic slave trade, you will not see the evidence before your eyes for the contemporary crimes of slavery and the slave trade that are occurring. This policy is available on the ICC homepage of the Office of the Prosecutor. And when I was developing it, many investigators came to me and said, I had not realized when I'm looking at the migratory flows in North Africa, that what I'm seeing is not kidnapping and abduction, I'm seeing slave trading and enslavement. Now I look at that child soul, I don't look at the monster, I see the enslaved child who's been continually slave trade. If I do not call a girl or a woman a bushman anymore, I understand those are enslaved females who are being continually enslaved. The past does allow us to see our present. And there is another reemergence of slavery crimes. Last December, the General Assembly of the United Nations agreed to set forth a 4-year time period to draft the first standalone treaty to address crimes against humanity. Until now, crimes against humanity has been a treaty based basically on customary law and every now and then placed into a statute of an adjudicatory body or a national penal code. The International Law Commission delivered a draft of the proposed Crime Against Humanity Treaty to the Sixth Committee of the United Nations. It did not include a provision for the slave trade, even though the responsibility of the International Law Commission is to promote progressive development of the law. This was not about progressive development. This is about inserting what is already in the codified into law. So Sierra Leone again proposed that the slave trade be enumerated into the three crimes against humanity treaty. Sierra Leone is joined by a group of friends and by large coalitions of the civil society. The reemergence of the slave trade is now gaining momentum. And my speaking to you tonight is part of that momentum. But the UK has, to date, not supported that provision of the slave trade globally, openly, and the new crimes against humanity treaty. So once again, I will say, there is advocacy to be done. There is remembrance to be had. And there must be a restoration of the prohibition of the slave trade and important international instruments. So this evening, I conclude by urging remembrance and recognition of the slave trade, and in particularly of acts of the internal slave trade. I urge that we as descendants and part of the international community understand those historic institutions. Is it painful to look back? Yes. But we have to look back out of respect of ancestors, but also to stand in solidarity with today's child soldier, with the women and girls and boys who are snared in forced marriages, with the migrants, with the enslaved who are in the detention centers in Syria, and forcibly disappeared. How can you be forcibly disappeared unless someone is exercising powers of ownership over you? And every time you're transferred to a new detention center, look at that as an act of the slave trade. We have to go beyond our images of plantation life. Get to the stevedores, get to the fancy girls, and get to the prisons in Syria. Full provisions prescribing the slave trade and slavery in international judicial statutes, in national criminal codes, and in the forthcoming Crimes Against Humanity Treaty is redress, is reparation, is the future. And I will close by just reminding you that slavery and the slave trade are loose ocean law, free trade law. Under international law, that means they have the highest status, can never be violated. Each violation invokes the irrevocable responsibilities of other states. Slavery and the slave trade is black letter law. I would claim it's the blackest of black letter law. But that's because it has been permeated with black law. Thank you very much for your attention.